Welcome to this video for purchases of immovable property. If you are watching this video, you have most probably decided to purchase a property. Before we continue with this informative video, give us the opportunity to introduce ourselves. MC van der Berg Incorporated is a well-established legal practice specializing in property law. Our head office is in Centurion with a satellite office in Pretoria East, and we conduct business in the Greater Pretoria, Centurion, Midrand, Johannesburg and surrounding areas. We have recently also opened offices in Durban and in Cape Town. The conclusion of a deed of sale and the ensuing transfer process can hold inherent risks if you do not obtain timely advice.
The aim of this video is to inform you, the prospective purchaser, about important matters that you should be aware of before you sign the offer to purchase. Throughout this video, we will be referring to the MC Purchaser's Guide, which is available on our website. There you will find more information on all the issues we are addressing today.
If you make use of the services of an estate agent, you should confirm that they are accredited by the Estate Agency Affairs Board of South Africa. An estate agent should be able to present his or her Fidelity Fund certificate to you as proof. Nowadays, estate agents are qualified professionals. You can expect the estate agent to assist you in the purchase of your property to be effective and professional. Bear in mind that the commission that an estate agent earns on the sale of the property is his or her financial remuneration and an incentive to introduce you to the right property at the right price. If an estate agent has introduced you to a specific property, you should not try to purchase the property directly from the seller. If you view a specific property through a specific agency, you must reveal this to both the seller and the agent if you are subsequently shown the property by another agent. You may be held liable by the original agency if you purchased the property they introduced you to, and thus were the effective cause of the transaction. The Consumer Protection Act does not apply to all transactions. Purchasers are sometimes given the wrong impression that they have certain rights relating to the Act, while this is not necessarily the case. The Act is only applicable if the seller sells a property in the normal course of business. In other words, if the seller is a developer or a speculator. If you purchase a property from the man in the street, then the Consumer Protection Act does not apply, and you cannot exercise any of the rights contained in it against the seller. The offer to purchase, which you made to the seller, becomes the deed of sale as soon as the seller accepts your offer in writing. It is therefore of the utmost importance that you take note of certain matters and obtain legal advice before you make an offer. Once you have signed the offer, you are bound by the provision of the agreement. Consult us before you make the offer to purchase. Remember, prevention is better than cure. In a typical transaction involving the transfer of a property, there are usually 3 registration actions that have to take place simultaneously at the deeds office. The transfer of the property, the registration of the purchaser's bond, the cancellation of the seller's bond. As the purchaser, you'll be involved with the transferring attorney, and if you take out a loan to finance the purchase, you will also be involved with a bond registration attorney. Let me explain the role and importance of the transferring attorney. The transferring attorney is the firm of attorneys that is responsible for the transfer of the property into your name at the deeds office. The transferring attorney must see to it that the conditions of the deed of sale is complied with by both the purchaser and the seller. Draft all the legal documents and see that it is signed. Ensure that the purchase price is secured. See to all the other financial aspects of your transaction. Coordinate the lodging and registration of documents at the deeds office with the other attorney firms. Reconcile the finances, and provide you with a final settlement account. As a rule, it is the seller's right to appoint the transferring attorney. As the purchaser, you can however negotiate with the seller and request that you appoint the transferring attorney of your choice. MC van der Berg Incorporated will be happy to assist you with the transfer of your property. There are two categories of costs for which the purchaser is responsible. The first is the transfer costs. The term transfer costs refers to the costs that are payable to transfer the property from the seller to the purchaser. The second category is the bond registration costs that are payable if the purchaser registers a bond over the property. The term bond registration costs refers to the costs that are payable in terms of registering a bond over the property. You're welcome to visit our website at www.mcvdberg.co.za and use the M-Cost calculator. The calculator and the explanatory notes that you will find here will give you an estimate on your costs, as well as a clear explanation of all the costs involved. Transfer duty is a tax payable to SARS before registration can take place. The amount, as determined by SARS from time to time, is paid over by us on your behalf, and we receive a transfer duty receipt as proof of payment. As mentioned above, the incorrect interpretation of the Consumer Protection Act may lead to purchasers wrongly assuming that they are entitled to expect that the property that they purchase is without defects. If the Act is not applicable, you are legally obliged to inspect the property thoroughly for patent defects, that is, defects that you can see or can be established by a reasonable inspection, before you make an offer. If the contract contains a footstewards clause, it means that the seller does not guarantee that there are no latent defects, that is, defects that one cannot see or that cannot be established by means of reasonable inspection. You are entitled to appoint a professional, at your own expense, to inspect the property on your behalf. Before the property can be transferred into your name, the transferring attorney must obtain a clearance certificate from the City Council that certifies that the City Council account for the property has been paid in advance. The opening of the utility account and the rates account can be challenging if you do not receive the right advice. When you sign the documentation at our offices, we will give you clear instructions which will advise you in this regard. We are obliged to hand in a clearance certificate from the sectional title body corporate and/or homeowners association to the deeds office as proof that these accounts have been paid in advance. We therefore ensure that these accounts of the seller are paid in full and closed on registration. We are required by law to see to it that certain certificates are supplied to us by the seller. These are then handed over to you. These certificates include the following: electrical certificate, electric fence certificate if applicable, and gas certificate if applicable. The extent of these certificates is limited, and they, for example, do not certify that all electrical, gas and electric fence equipment are in working order. To date, there is no legal requirement that the building plans for the particular property have to be in order before we can transfer the property to you, the purchaser. You can, however, add a condition in the deed of sale that you be supplied with the approved building plans before transfer takes place. It is then up to the seller to accept the offer with your condition or to decline it. The date of occupation is the date on which the seller must give you undisturbed possession of the property. If you have to move in on a specific date, you must negotiate the date of occupation when you make the offer to purchase. If you agree in the deed of sale to take occupation on a specific date, you are contractually and legally bound to do so on that date. Even if you actually move in at a later date, you will still be responsible for occupational rent from the date mentioned in the deed of sale. We suggest that you include a full list in your deed of sale or add an addendum in which you specify which items are regarded as fixtures and thus form part of the property. If you're applying for a loan to finance the purchase price, you must make the deed of sale subject to the suspensive condition that you first have to obtain a loan and bond approval. It is important that you obtain the bond approval as soon as possible, as the transfer process cannot proceed before all suspensive conditions have been met. The bond registration attorney is the attorney firm that oversees the registration of the purchaser's bond. It can be the same firm of attorneys attending to the registration of the property, but it can also be a different firm. The bond registration attorney must be on the bond registration panel of the bank where the purchaser applied for the bond. Some of the banks will allow the person taking out the loan to request which attorney firm must register the bond. If you would like our firm to see to the registration of your bond, you must give this instruction to your personal banker or the bond originator. Not all attorney firms are on the various banks' bond registration panels. MC van der Berg Incorporated is on the bond registration panels of Absa, FNB, Nedbank, Standard Bank, Investec and HIP or Housing Investment Partners. If any funds originate from the sale of another property, add a clause to the deed of sale stipulating that you are also selling your property and make the offer you are making subject to the sale of your property. If you have to obtain a loan, the bank can make the registration of the bond subject to such a condition. FICA is an acronym for the Financial Intelligence Center Act. This act requires the nominated persons and institutions that are involved in your transaction to verify certain information and keep records of it. FICA also requires attorneys to report suspicious transactions, such as when large amounts of cash changes hands, to the FIC, or the Financial Intelligence Center. You should under no circumstances pay the seller cash on the side in an attempt to avoid transfer duty. Why MC van der Berg Incorporated? Your expectation is our mission. As mentioned earlier, the seller is entitled to appoint the transferring attorney, but you may negotiate with the seller to appoint a transferring attorney of your choice.
We are a dynamic and positive team that believe that all people matter. The MC van der Berg team is ready to assist you and to look after your interests.
Visit us at www.mcvdberg.co.za and read our MC Purchasers Guide. It is packed with useful information. You can also contact us at 012-660-6000 or send us an email to info@mcvdberg.co.za.